Good morning, everybody.
Good morning, everybody, sir.
Justice M.M. Kumar, member NHRC, former Chief Justice of the Jammu and Kashmir High Court, and former President NCLT. Dr. Krishnamurthy Subramanian, Chief Economic Advisor, Ministry of Finance, Government of India. He hasn't yet joined us, but he said he asked us to start, and he's going to join us in about 15 minutes. Mr. Nikhil Shah, Managing Director, Alvarez and Marshall. Mr. Krishna Dutt, Managing Director, Argus Partners. Mr. Suharsh Sinha, Partner, AZB and Partners. Mr. Kaustubh Kulkarni, Group Head, Mergers and Acquisitions and Strategic Financing, JSW Steel Limited. Ladies and gentlemen, a very warm welcome to all of you to the National Conference on 5 years of IBC 2016 and the way forward. Thank you all for joining us today and being a part of this conference, which is being organized under the aegis of the CII Task Force on the Ease of Doing Business. We are very honored to have amidst us our two guests of honor. Actually, one right now, but another one will be joining us soon. Justice M.M. Kumar and Dr. Krishnamurthy Subramanian. During his illustrious career, Justice Kumar has played a pivotal role in creating a favorable investment climate for doing business. Having served as the first president of the National Company Law Tribunal, he contributed greatly to setting the precedents for resolution of insolvency issues based on a robust framework and focused principles. Sir, we thank you for taking the time out from your busy schedule to join us at this conference and for sharing your views on the progress made thus far under IBC 2016. Dr. Subramanian has been spearheading initiatives for providing an impetus to economic and industrial activities and has been pursuing reforms in the domain of insolvency. He is a good friend of industry and CII and has been very receptive to our recommendations from time to time on industry issues and business reforms. Whenever we have sought his guidance and direction on any policy issues, Dr. Subramanian has been very quick to respond, which has been a great source of encouragement for us. CII will continue to work with him on ease of doing business issues, including those pertaining to resolving insolvency in order to sustain the momentum of reform and to streamline the process of reviving the economy. I would also like to thank our eminent panelists from the legal fraternity and the private sector, Mr. Nikhil Shah, Mr. Krishna Dutt, Mr. Suharsh Sinha, and Mr. Kaustubh Kulkarni for joining this very important session. We are confident that your subject expertise and on-ground experience in restructuring, revival, and liquidation of firms will be very useful for the deliberations today and will result in some very useful and important recommendations. We would like to start the session by congratulating the government on the completion of 5 years of the Insolvency and Bankruptcy Code 2016, which is one of the most comprehensive legislations because it consolidates into its structure both rehabilitation and liquidation. Over the years, the code has been successful in meeting its objective of restructuring and resolving insolvency of corporate persons, partnership firms, and individuals, while leveraging the maximum value of assets. This is borne out by the fact that 394 cases have been resolved until 30 June 2021, wherein financial creditors, including financial institutions, had total claims amounting to 6.8 lakh crore rupees, out of which 2.5 lakh crore rupees have been realized. The reorganization process accessible under the code provides an efficient mechanism to reinstate financial viability and better prospects to realize the optimum value of assets. Since its implementation in May 2016, the IBC has effectively addressed the issue of bad loans and non-performing assets through its robust framework, even during the challenging times of COVID-19. The authorities must be lauded for addressing the difficulties of firms in such a speedy manner and for introducing various reform measures for mitigating any negative impacts on industry. Some of these notable reform measures include temporary suspension of initiation of corporate insolvency resolution processes based on fresh defaults under the code, increase in the default threshold for the initiation of CIRP, and certain measures by RBI to enable granting of moratoriums and to facilitate restructuring of distressed assets. With the government working in mission mode to strengthen the code, several more reforms are being implemented. The most prominent one being the introduction of a special pre-packaged insolvency resolution process to deal specifically with distressed MSMEs. This is expected to be more time and cost efficient than CIRP, and industry must make full use of this new framework. While great progress is being made in the domain of resolving insolvency, much more needs to be done to ensure that companies are not forced into liquidation and stakeholders do not suffer for being unable to carry out activities or forced to rush to NCLTs to seek necessary exclusion of time owing to litigation from different stakeholders, which adds to costs and causes unpredictability. It is undeniable that as the Indian economy recovers from the slowdown, industry will continue to need liquidity support from the government to promote reconstruction, particularly in priority sectors like real estate. In this context, as we begin the deliberations for the day, I'd like to take this opportunity to highlight a few key recommendations for the consideration of the policymakers and the legal fraternity. First, the authorities must promote out-of-court restructuring and one-time settlements for the larger benefit of all players in the economic landscape. In this regard, a scheme with inclusive standards should be developed based on thorough stakeholder consultation. Second, the delay in the resolution process, with greater than 71% of cases pending for more than 180 days, is indicative of the fact that judicial delays and regulatory uncertainty must be addressed on a priority basis. The resolution process under the code must be expedited, given that the time taken for the conclusion of the process is far exceeding the prescribed statutory timelines. Time and cost efficiency, along with predictability of the insolvency resolution outcome under IBC, plays a key role in boosting investor confidence. Third, as the focus of the government is to integrate with global value chains, foreign investments may be attracted by allowing a greater number of resolution options. This will encourage specialized distressed funds to participate. Further, foreign investment in stressed loans should be invited either through the bad bank route or by introducing a more liberal framework for sale of loan exposures. Fourth, the government should continue to enhance resources for capacity building of NCLTs by increasing benches as well as improving their virtual hearing and case management tools. Special benches of sectors for sectors such as MSMEs with domain expertise may also be constituted. Fifth, as suggested by the Standing Committee on Finance, an institute of resolution professionals must be established to regulate functioning of resolution professionals in the nation. Capacity enhancement programs should also be conducted for insolvency professionals and information utilities. Sixth, even as we inch towards normalcy, there must be greater adoption of technology for holding virtual meetings of courts and committees of creditors. And artificial intelligence should be deployed in various insolvency procedures in order to expedite the restructuring process. With these few words, let me take you through the broad structure of today's conference. The first session of the conference will resolve around the topic of assessing the achievements and learnings from the implementation of the Insolvency and Bankruptcy Code 2016, identifying ways to deal with the post-pandemic deluge of NPAs, ensuring fast tracking of liquidation closure and dissolution of corporate debtors, and developing a code of conduct for committees of creditors. The second session is IBC 2016 and financial stakeholders experience so far in the way forward, which will focus on important issues like the deterioration in the valuation of companies and restructuring programs post-COVID-19. Then we have a session on recent policy and judicial developments towards IBC 2.0, which will involve deliberations on topical matters like the findings of the Standing Committee on Finance and pre-packs for MSMEs in India. Finally, we have the plenary session, which Sri Rajesh Verma, Secretary, Ministry of Corporate Affairs, at the end. I once again welcome all of you to this national conference on 5 years for IBC 2016 and the way forward, and look forward to your active participation throughout the day. May I now please request our first guest of honor, Justice M.M. Kumar, to please deliver his special address. Justice Kumar. Muted. You're still muted, Justice Kumar.
Thank you very much, Mr. Milan Nag. Good morning to everybody. Dr. Milan Nag is a co-chairman of Confederation of Indian Industry Task Force on Ease of Doing Business and chairman and MD of KK Nag Private Limited. Mr. Nikhil Shah, MD of A&M, then Mr. Subramanian, has he joined, Mr. Subramanian? I don't think so.
Sure, sir.
Then we have very illustrious panelist, Mr. Krishnava Datta, Managing Director, Argus Partners, Mr. Sohraj Sinha, Partner AZB, Mr. Kaustubh Kulkarni from JSW. Ladies and gentlemen who are joined the session, Confederation of Indian Industry, if I remember correctly, is more than 125-year-old organization. When I was Chief Justice, Jammu and Kashmir High Court, in Srinagar, flash floods hit and the river Jhelum did not know any bounds. The city was deluged in almost 8 feet water. My own house was in 8 feet water. Then at that time, the Srinagar chapter of Confederation of Indian Industry contacted me and requested me to take up the cases concerning insurance cover, because we have to organize the High Court in a house of a judge. So with the permission of the then governor, we converted the house of a judge into a High Court, because High Court never stopped functioning. So CII played a pivotal role all over the country. I greet the Confederation of Indian Industry for organizing this conference to assess 5 years of IBC and the way forward. I think it will go a long way in discussing the issues which during this period from December 1, 2016 till today have surfaced. As all of you know, the IBC was enacted with effect from 1st of December 2016. Technically, it may not have completed 5 years, but it is, one can say, in the 5th year. IBC brought a paradigm shift in the solution of stress assets. Earlier, the debtor used to remain in command. The possession of the assets would always continue to be in the possession of the debtor. It was debtor-oriented law. But IBC brought a paradigm shift, and the possession administration was given to the creditors, and through the creditors would control the assets and the administration through the insolvency professional. New institutions like National Company Law Tribunal, National Company Law Appellate Tribunal, IBBI, Insolvency Bankruptcy Board of India, Information Utility, Insolvency Professionals, those new institutions were created. When the cases started pouring in late December 2016 and January 2017, in front of NCLT, which was described as adjudicating authority under the IBC, there was only a bare statue. And we started applying, interpreting, and banking upon the past experiences under Section 433 small e of the Companies Act, which provided for winding up, we started deciding cases. And the law, as all of you know, has developed at a very rapid speed. And the role of the bar, role of the insolvency professional, role of the industry, the role of the IBBI, I think each one of these stakeholders has contributed immensely for the development and evolution of the law as it stands today. Friends, I can share with you few areas which were completely virgin, and today there is some sense of certainty given to those areas by virtue of judgments of the adjudicating authority, appellate authority, and Honorable the Supreme. One lesson which we must have seen, we must have learned is that IBC cannot be studied in isolation. You must have knowledge of company law, law of contract, interpretation of contractual clauses, and interpretation of Statute Limitation Act, so on and so forth. So IBC cannot be practiced, cannot be studied, cannot be applied in isolation. Now, when the cases started pouring in, and few cases which came in the beginning, they were barred by limitation. The question under the before the tribunal arose whether a petition which has been filed with regard to a default committed, say, 5 years ago, would it be barred by limitation? There was no provision in the Insolvency Bankruptcy Code providing for any period of limitation or application of the Limitation Act. We decided in the NCLT that the period of limitation would apply. Tribunal cannot be considered to be a forum for barred or bad debts. So therefore, we decided, and the judgments of the NCLT were that the Limitation Act applies and period of 3 years would be attracted. But the Appellate Tribunal took the view that since 1st of December 2016 is the date of promulgation of the Insolvency Bankruptcy Code, the remedy to a financial creditor or an operational creditor become available only on 1st of December 2016. Therefore, 3 years thereafter would be whether the debt was of 2012, whether the debt was of 2013. So the Appellate Tribunal took the view, no, it is within limitation. The matter traveled to Supreme Court, and in the meanwhile, the looking at the controversy between the Appellate Tribunal and the judgment of the adjudicating authority NCLT, the legislation also inserted section 238 capital A and provided that the Limitation Act would apply insofar it is possible. So ultimately, Honorable the Supreme Court in BK Education versus Prag Gupta 2018 held that the Limitation Act limitation period would apply, and in any case, after the amendment was enacted by by adding 238A, the period of 3 years would apply retrospectively. It was always there. The second part of this area is if a default has occurred, say 3 years back, 4 years back, 5 years back, and before the debt become time barred, there is acknowledgement whether section 18 would apply or not. Section 18 would mean that there would be fresh release of limitation. So that was also clarified by Honorable Supreme Court in the case of Babulal 2020 that section 18 of the Limitation Act, if that is acknowledged by the corporate debtor before the completion of period of 3 years from the date of default, then it would be within the application would be considered to be within the period of limitation. However, a very important development which need to be noticed is that NCLT principal bench has taken the view that Article 61, 62 of the Limitation Act would apply to cases where there is a collateral security in the form of immovable property. And the period of limitation prescribed there is 12 years. The Supreme Court disagree with this view by saying that immovable property, that Article 61 applies to suits, not to the application. Section 7 or Section 9, for that matter, even Section 10, use the expression application. Therefore, suits are not to be governed by Section 7 suits. It is suit only which can be which can attract Article 61 or 62. But application cannot attract article. As a result, number of articles in various journals are written that banks may feel the pinch of it. But the saving grace was that condonation of delay application could be filed. Then the extension of limitation period during the pandemic, 15th of March 2022, 14th of March 2021, by Supreme Court was extended. 1 year period was not to be taken into account, and then suspension of insolvency resolution proceedings by adding section 10A from 25th of March 2020 to 24th of March 2021. Any default, if have occurred, cannot constitute the basis for filing an application under section 7 and 9. And the court has clarified that this type of default can never be invoked for the purposes of insolvency resolution process. However, it must be clarified that the default which have occurred earlier but brought within the period of limitation, even in 2021, they will not be hit. If there is a default, say in February 2020, the proceeding can be initiated in respect of such a default. So then the issue of home buyers has confronted the courts more often than not. The first case in January 2017 came up before the principal bench, and we decided that is Nikhil Mehta versus AMR infrastructure. I think most of the listeners know about this matter. 23rd of January 2017, we decided this matter and held that time value for money is a concept, and since a purchaser of a house would not answer this, we dismissed the petition. However, the appellate tribunal took the view that in cases of assured returns, the time value for money element is met, therefore the application would be competent. But then Second Amendment added explanation to Section 5, subsection 8, clause F, and that where the home buyer were held to be financial creditor. When the amendment was challenged in Pioneer Urban Land Infrastructure in 2019, the Supreme Court said that home buyer implicitly were included in Section 5, subsection 8 and clause F. The amendment was held to be retrospective and clarificatory in nature. And then in 2020 judgment in Amarpali's case, which has brought back the concept adopted in RERA, that the money deposited by the home buyer has to be kept in escrow account, how the Amarpali licenses have been cancelled. That very elaborate judgment by the Supreme Court has been given in 2020. Then the issue of minimum threshold. In Section 4, initially, the amount for moving an application under Section 7 or under Section 9 was 1 lakh. That a person who is unable to pay even a sum of rupee 1 lakh has to be considered insolvent. But taking into account the large number of cases which were being filed and the interest of small industry, the amount was increased to 1 crore. So the maximum amount which was provided in the proviso to Section 4 was by notification was increased to 1 crore. Then the amendment cannot be regarded as retrospective, it is prospective. It would not apply to the pending cases which have been filed on the basis that default is of 1 lakh or more than 1 lakh but less than 1 crore. The very interesting amendment came for MSME, that pre-pack. This is you see, in a mature system like England, pre-pack is evolved by the professionals. It is not part of any statutory enactment like they have 1986 code, which we have borrowed heavily. And there the pre-pack is slightly in a different form. There, when an industry start thinking that they are on the declining path, they try to pull in another investors, another person who can infuse finances with them. So they enter into an agreement that in case an application for before the insolvency court is filed and administrator appointed, then this agreement would come into play. You will join us and there would not be any insolvency proceedings. Within week, 10 days, the whole thing is settled. Such is the system there. When we talk to the judges there on a tour which we took in 2018, when we talked to the judges there, they said we have no idea, but sometime a barrister come and mention that there is a pre-pack already. So they settle within a week and the administrator put his seal of approval. Mind you, in England, administrator is all in all, he calls the shot because they have a very mature system. The creditors are guided by the administrator all the time. But here the pre-pack is confined to MSME. Whether this should remain confined to MSME is a matter of debate, or it needs to be universalized, because it is such a thing. If there is a demand by large number of entrepreneurs that possession should continue to be with them during the corporate insolvency resolution process. But whether by pre-pack system applicable to MSME, possession continues to be uh, with the debtor, with the entrepreneur, rather than going into the hands of the IRP. So whether it should be universalized and what should be the parameter, those may have to be seen. Then there have been controversy with regard to financial creditor versus operational creditor. Appellate tribunal has had so many things. Eventually, Supreme Court, while deciding Swiss ribbon, has put the controversy to rest by saying that these two creditors belong to two different categories, and their distinction is based on a rational basis, and there is no arbitrariness, no violation of constitutional provision like Article 14 and 16. Now, another controversy which uh, appeared before the appellate tribunal was whether an entry in the balance sheet would amount to acknowledgement of a debt on the part of the corporate debtor. The appellate tribunal by majority took the view that no, it will not be acknowledgement, because by compulsion of law, such an entry is required to be made in the balance sheet. But this view of the appellate tribunal has been reversed by the Supreme Court in a recent judgment, that is Vishal Jaiswal, Asset Reconstruction Company, Vishal Jaiswal, 2021. The Supreme Court has taken the view that acknowledgement of debt in the balance sheet would amount to acknowledgement under Section 18. Therefore, it will extend the period of limitation. However, they added a caveat that if the corporate debtor puts a qualification that this will not be considered acknowledgement because it is being made under compulsion of law, then Section 18 may not be attracted. So then huge controversy on the issue of personal guarantors were there. When the notification was issued, challenged before the Supreme Court, and Supreme Court has now clarified that the personal guarantors stand out of corporate insolvency resolution process, and approval of the resolution plan by the COC or its sanctioning under Section 31, subsection 6, approval by the NCLT would not discharge the personal guarantor. They will continue to be liable. Then the question is of cross-border insolvency, whether the cross-border insolvency should be incorporated now, because already reports by the Ministry of Corporate Affairs are there. A very big committee was appointed to go into this area, but cases have started pouring in. Jet Airways case before the appellate tribunal was one example of such a nature, where the direction were issued, and the person who has come from foreign land where the jettier with plane was parked, he came and COC was directed to allow him audience. When COC did not allow him audience, the appellate tribunal stopped and issued binding directions. So this area may also be required to be explored. One important issue which I would like to mention is valuation. Valuation has so far been not given the importance which it deserves to be given. Then valuation, fair market value, liquidation value. These two valuation, how they are to be done, what are the factors? 2017 under the Companies Act, IBBI has framed rules, but those rules are not applied very often. This area also needs to be considered very seriously. So friends, the various judgments by Supreme Court have been delivered. Innovative on Section 7, Swiss Riven on constitutional validity of the IBC, Mobilox under Section 9, Quine and Urban upholding the definition of expression home buyer in explanation 2, Section 5.8, Clause F, Hotel Godawan, Bhushan Steel. So many judgments of the Supreme Court have come, which has shown the rapid evolution of law. I would say that recently Mr. Jayant Sinha, chairman of the Parliamentary Standing Committee on Finance, the report has come. There is dissatisfaction expressed on the working of the IBC. One area which Mr. Sinha has highlighted is 60 to 90% haircut. Framing code of conduct for the COC. Because Supreme Court have said that even if COC has approved a plan which is lower than the liquidation value, NCLT or NCLAT has no power. Because as a principal bench, I had taken the view that if the resolution plan is less than liquidation value, then it is better to go on liquidation and have better liquidity in the hands of the creditor than allowing the resolution plan which is below the liquidation value. But that view is no longer correct view. Supreme Court have said, no, even if it is below liquidation value, the COC in its commercial wisdom is entitled to take that view. Now Mr. Sinha says that in his report that 60 to 90% haircut. The appellate tribunal chairperson, Honorable Mr. Justice Mukhopadhyay, used to say 007 haircut. 007 haircut. And when you talk of 95% haircut, over 90% haircut, I think that 7 also goes for a toss. 007, but remains after it is 95% haircut. So the second area which Sinha's report highlight and underline is the poor infrastructure, poor manpower, poor members strength. 64 is the strength of the member of the NCLT. When I left in January 2020, we were 52. Today we are less than 30. We are operating from 14 locations. And one bench is tackling 3 benches, 3 other benches. How you can expect that there will not be delay. It is bound to be there. No matter how hard a member may keep working, then the supporting staff all outsource, contractual. This also has this Sinha's report is has highlighted these features. And when he talks of the COC and framing of code of conduct for COC, then there are some issues. Professionalism is lacking. Professionalism is lacking at various levels. Insolvency professionals, member of COC, and other areas. There has to be some rethinking on those areas, how we can revitalize, galvanize those areas so that the forces which are not adopting professional practices are requested and persuaded to adopt only professional practices. How to instill professionalism in all the stakeholders, I think, is another area highlighted by Sinha's report. I think pre-pack may have to be universalized. Another area would be how to rehabilitate the directors of those corporate debtors who have been subjected to CIRP process, either by liquidation or by resolution. There are certain black marks on some of the directors. I think their national assets, their rehabilitation program should also be there. They may be debarred from year, 2 year, 3 years, whatever, but they cannot be permanently kept out of the system. They have so many good qualities of entrepreneurship, which other may not. So therefore, I am conscious of the time. I think I will bind up by saying that IBC has developed very quickly and rapidly, and there are more milestones to be achieved. And I think Sinha's committee report must have shown some path to the government, and they must realize that because the recommendations were made in December 2019, 24 members were recommended by Supreme Court committee headed by the present CJI, but those have not transpired. And such a number of various things happen, like we have 7 presidents of the NCLT. Somebody would come, join in the morning as a president, next day somebody else will come. So those type of things should be are absolutely avoidable. I don't think we can have that type of system. The whole world is watching us. And in 2018, our performance had gone so well that GRR, which is an independent agency in London, they gave us the annual award for rendering some path-breaking judgment. The earlier year award has gone to Singapore, but 2018 award was given to NCLT. Now we must dream for a very good days ahead, and I am sure that people who matters, they will listen to our voice, and the CII, by playing its pivotal role, will recommend to the government the takeaways from the today's all 4 session, and I am sure we will make some difference. I am grateful to the CII and to Mr. Nag for granting me the opportunity to share my views. Thank you so much. Good day.
Thank you so much, Justice Kumar. It was a very interesting talk, and I wish we had more time because it was really very interesting. I remember this incident about you and your family being rescued from the floods.
Yes,
I think it was in the middle of the night, wasn't it? It was in the papers, and also about your holding court at your residence. I had no idea that CII had a role to play. So I'm so happy to hear that. And thank you very much for telling us.
A lot of cases before me.
Thank you. Thank you so much, sir. Now I'd like to welcome, I'm so happy that the Chief Economic Advisor, Dr. K.V. Subramanian has joined us. Sir, before I invite you to speak, I just want to there was something I said in my opening remarks that I wanted to about you. I said that you've been spearheading initiatives for providing an impetus to economic and industrial activities and have been pursuing reforms in the domain of insolvency. You've been a very good friend of industry and particularly of CII, and you've been very receptive to our recommendations from time to time on industry issues and business reforms. Whenever we've sought your guidance and direction on any policy issues, you've been very quick to respond, which has been a great source of encouragement to us. And CII will continue to work with you on ease of doing business issues, including those pertaining to resolving insolvency, in order to sustain the momentum of reform and to streamline the process of reviving the economy. So I thought I'd just repeat that in your presence. And may I please ask you to deliver your address, sir. Welcome.
Thank you very much, Mr. Nag. Very good morning to all the esteemed dignitaries who are there on the virtual dais and the participants in this national conference on 5 years of IBC. I think pretty much every speaker has mentioned that this is a seminal reform. I have absolutely no doubt that that is indeed the case. So I'm not going to belabor on that aspect. Instead, I'm going to try and keep my remarks focused on what we can do going forward, and primarily at the big picture level as an economist. So I think the major change that the IBC has brought, and I say this as someone who worked in a financial institution. My first job out of IIMs was with a financial institution. Worked for 2 years before I went for my PhD abroad, and had been observing the SARFAESI. While I was doing my PhD, SARFAESI was passed, and yet the entire bad loans crisis happened with significant willful defaults. And when I correlated it with with the experience when I was working with a financial institution, and when I look at the post-IBC scenario, for me, what stands out, I think, is given my inclination to try and say things the way I see it, I will mention that before IBC, there used to be this feudalism where the corporate debtor took it to be his divine right, his or her divine right to be, in control. In fact, I used to, even before my PhD as well, when working for a creditor, I used to be sometimes quite taken aback by the mindset that used to be displayed at that time. Because one had learned in business school that there were certain features to an equity contract and certain other features to a credit contract, and none of us was taught that that the equity contract basically involved a divine right to be in control. At least that was not what was taught in theory, and to be then observing what we did observe in practice at that time was quite I would say learning at for a young age at that time. I think maybe when you're young, sometimes actually practical realities do not confront you, and idealism prevails. But I think the very good thing that I've actually observed now is that there is a very, very clear recognition that those days are gone. That feudalism actually is something that ain't coming back. And I think that to me, that is actually a very, very important aspect, something that all of us, as and especially people here who have contributed enormously to this particular setup, I think really need to congratulate themselves. Feudalism is never ever good, but feudalism in a capitalistic system, I think, is possibly the worst. And I think, that being able to actually sort of, being able to bring that change is very important. But at the same time, I will actually say, and based on some of my early research on the bankruptcy law changes in the US, one realizes that the move away from feudalism, in a more de facto manner, compared to de jure, is a hard-fought battle. Those that have benefited from the status quo of a system that enabled them to be in control are not going to quickly cede ground, and therefore that ground has actually to be has to be slowly but surely taken away through the concerted efforts of all of us, and create a fair system. I think what we are taught in theory actually is a very fair contract. The fact that the equity holder actually remains in control, only when things are going well, because the equity holder actually keeps all the rewards that come from taking risk, if things go well. So the equity holder actually never complains when good luck actually delivers a lot of rewards to him or her. And I think the flip side therefore is, if actually things are not good, bad luck, then actually that is part of the risk taking, and therefore things, you have to actually then provide the creditor the right to be able to think about actually somebody else. And I think that is part of the contract. Nowhere in the world, can you have in a capitalistic system where you can have your cake and eat it too, which is basically what one has to recognize. So I think while there are of course egregious cases of willful default, etc., but I think what we also have to recognize is that if one gets to keep the rewards from good luck, I think, and that is part of the equity contract, then when the same thing actually on the flip side happens, I think the other part of the contract has to be honored as well. I think these are important aspects. Now, therefore, I actually want to talk about something, in terms of the progress. What I want to lay out is an integration of the of what has been part of our heritage, what we've inherited, as Indians, together with the, with basically the Western capitalistic ideas. And I am briefly referring back to the 2020 economic survey, which media outlets had called old wisdom combined with modern economics. If you go and read, for instance, in our literature, and actually note that I'm not calling it scriptures, I'm calling it literature. Anything that is part of the written word, whether it is actually in Sanskrit or or other language or English, is literature, and I think that's the way we have to treat it. And we as Indians have actually been very, very lucky to actually inherit a very rich literature, not only in various aspects of life, but in economics as well. Arthashastra, for instance, in the north, Tirukkural actually in the south. Of course, Tirukkural has other aspects as well. But I think these ideas have really remained with us. So the exhortation that I want to make to all the participants is using the idea of Nash Equilibrium versus Pareto Optimal. These are jargons, but I think those of us who've seen the wonderful movie A Beautiful Mind on John Nash will certainly have understood what a Nash equilibrium is. There's that wonderful scene where where a woman is being quoted, and that's what gives John Nash the idea of the Nash equilibrium. So I think I'm not going to belabor the idea of a Nash equilibrium, but the simple idea there is that systems, whether it's IBC or other systems, can be caught in inefficient equilibriums, equilibria, when each agent justifies his or her suboptimal actions by saying that, other entities are actually behaving suboptimally, and therefore I am behaving suboptimally. When you have entity A saying that, I am doing what I'm doing because B is doing what he or she is doing, and B says the same thing as well, you get stuck in this suboptimal equilibrium. And this is where leadership really starts coming in. And I think that is what is actually required for each constituent. The Honorable Chief Justice spoke about some of these issues, about appointments, etc. And I think what I'm speaking is very, very relevant. The problems that he's talking about can actually be indeed seen through the prism of Nash Equilibrium versus leadership, and that's something that I want to talk about. So, in our heritage, we have been taught something that is so beautiful, and as an economist, when I think about the concept of dharma, I think having learned economics, having learned about incentive contracts, even incomplete contracts, Oliver Hart and others actually got the Nobel Prize a couple of years back for work on incomplete contracts. But when you think about the concept of dharma from an economic angle, you start realizing why it was such a powerful idea. Because in the real world, contracts are always incomplete. And contracts and explicit contracts can oftentimes crowd out intrinsic motivations. And there can be the problem of, the problem of commons, or the tragedy of commons that results where, behavior that is socially optimal versus behavior that is individually optimal for an agent, there is a wedge between the two. And I think, in the case of IBC, you can clearly see that there are some actions that every stakeholder can take, which would be optimal for the entire IBC system as a whole, vis-a-vis what every entity is doing that is basically privately optimal for them. And this wedge is what is actually leading to the preservation of this Nash equilibrium, where we are stuck where we are, where we are. So I think this concept of dharma, which actually creates a pole star saying, don't just look at it from an I, me, myself perspective. The entire concept of dharma is there is a much bigger goal actually. And in some sense, if you think from an economist perspective, dharma is actually this concept of, aspiring for what is socially optimal. When you do your actions, you actually do what is socially optimal rather than basically what is privately optimal for you. It's such a powerful concept. And I think, all of us have been incredibly fortunate to have basically been told this idea. I think the fact is that we learn about this, let's say when we read the Bhagavad Gita, but I think the most important thing is to actually bring it into action. Those of you who've heard Sri Rajagopalachari's commentary on the Bhajagovindam, as a tambram, that's something that I was exposed to. Before you hear M.S. Subbulakshmi's beautiful rendition of Bhajagovindam song, you hear Sri Rajagopalachari talking about wisdom. And he says that knowledge that does not issue in action is useless tinsel. I'll say it once more because it's such beautiful words. Knowledge that does not issue out in action is useless tinsel. And I think this concept of dharma, if it actually only remains knowledge that does not issue out in action, becomes useless tinsel. And I think that is what we actually need, all of us as stakeholders, to really remind ourselves of our dharma and act in accordance with our dharma, in which case I think it'll be very easy to actually get out of this Nash equilibrium that we find ourselves in. Instead, get on to what is actually what we economists call Pareto optimal. If every stakeholder, and every agent in this system just does what he or she thinks about dharma, and that is something just based on an internal compass of what is socially optimal. I think, a lot of these debates that we are having actually will not be required at all. We'll be very quickly hitting actually the efficient outcomes. We are continuing to be in this, Nash equilibrium only because, many of us actually have, I think, just read about it as a concept. But, as Sri Rajagopalachari actually said, it is knowledge that is not issuing out in action. And I think that is something that we have to, and even from a more prosaic point of view, if you think about it, leave these, elevated angles. But even from a very prosaic point of view, just think about leadership. What is leadership? Leadership is never I cannot actually identify a leader who was called a leader because of his actions, where he said, hey, I'm going to behave this way because others are behaving in a certain way. That is not what we identify as a leader. A leader instead is someone who says, 99.9% of the other people can behave the way they are behaving. I will actually, based on my internal compass, will behave, in the first best manner. That is what we all identify as a leader. If you think about actually, and let me give you an example from cricket, something that I'm quite passionate about. When Saurav Ganguly, came and became the captain, before that, Indian captains were very happy actually winning at home. And he could have easily said, that's my objective as well. But, though 99.9% of captains have thought like that before, he said, no, that is not what I'm going to do. I want to be a leader, and therefore I want to actually make India really capable at, abroad as well. That is what leadership is all about.
उनका रिस्पॉन्स भेजा था आपको?
मैंने देखा मैम।
हाँ। मैं अभी राजीव के साथ हूँ, 15-20 मिनट में हो सके तो ज्वाइन करती हूँ।
I'm sorry, I'm not sure where that voice is coming from.
That's okay.
Please go ahead, sir.
It looks like I broke my train of thought. So as I was saying, so what is important is that, we actually think about it as a leader, where the notion that, your actions are justified because others are behaving in a certain manner. That's not how anybody becomes a leader. And I think, and I can put it, in a even more specific manner. If there are X people or X agents or X, institutions that are behaving in a suboptimal way, and that is used as a rationale to say, I as an agent or an institution also will behave in a suboptimal manner, then you go from X to X plus 1. And when you have these accumulations of X plus 1, X plus 2, and so on, you get to an equilibrium, of Y, where there's actually Y people behaving suboptimally compared to X, Y greater than X. In contrast, when you say it may be the case that X are behaving suboptimally, but I will behave optimally, you go to X minus 1. And from X minus 1 to X minus 2, so on, that's when you get to an equilibrium of Z, where actually Z are behaving suboptimally compared to X, Z being less than X. And I think this is, again, let me end by saying that for many people here, especially some of the people who are experienced and have seen far more of the world than I have, you may actually think, hey, this young guy is just basically talking impractical stuff. Let me, based on the experience that I've had, if there is one word I actually thoroughly dislike, it is this word practical, because it is oftentimes just actually an alibi for sticking to compromises. In contrast, a word that really inspires me a lot is ideal. So why don't we actually think about disbanding that word practical and instead actually stick on to the word ideal? And I think that may that simple thing can do us a world of good. I'm sure a lot of people will have micro suggestions and other detailed suggestions to give, but I think all of that may not be enough, may not be really sufficient unless this macro perspective of dharma, of showing leadership, is actually taken into account, and really thinking about taking that knowledge and bringing it into action. I wish all the good luck to all the participants and those who are part of this wonderful conference. I am absolutely sure that that progress will happen going forward, and that the next time we're actually talking about this, maybe at the 10th anniversary of IBC, we will all be congratulating ourselves at the wonderful progress that we've made, that in the next 5 years. Thank you very much, and once again, good luck.
Thanks very much, Dr. Subramanian. That was an excellent address. It was I think your description of the economy being feudalistic was so accurate, and it's amazing that it's taken us 70 years after independence to ban the zamindari in the economic sphere. So it was fabulous. And I think just to go on with your this idealistic goal that you've set. Idealistic, not in impractical, but just the right goal that you've set. I would add that it's our karma to achieve that state of dharma. So with that, I'm gonna ask Nikhil to take over now. May I beg your indulgence, because we are running very far behind schedule. This session was supposed to start half an hour ago. So can we extend the session by 15 minutes and go on till 11:30? Is that okay with all the panelists and the guests of honor?
Well, Mr. Nag, may I beg leave, and because I have other commitments, as
Okay.
you know,
I apologize, sir. You will feel. Why don't you stay on and feel free to leave whenever you need to? Yeah.
Very well. I have to go, in fact.
Okay. Thank you very much, sir. It was a great honor having you. Thank you.
Sorry.
Nikhil, I'll hand it over to you now to take it from here, and let's close it at 11:30, please.
Sure. Thank you,
Thanks.
Milan. Good morning, everyone, and thank you to CII for organizing this timely conference on the IBC. As mentioned by Justice Kumar as well as Dr. Subramaniam, the IBC, as most of you know, has been largely successful and has provided a consolidated platform for lenders to recover their dues in a time-bound manner compared to other mechanisms that existed pre-IBC. The IBC has really improved the financial behavior of debtors and creditors, strengthened creditor rights, improved recoveries by a magnitude of 2 to 3 times, and shortened the resolution timeframes significantly from where they were earlier, and has allowed for the reallocation of capital and resources and helped create a secondary market for stressed assets, all in a very short period of 5 years. I think what we should focus on in our panel at least is with the evolution of time, the IBC has also seen a fair degree of challenges. Some of which were mentioned by Justice Kumar in terms of the limited bench strength, some of the lengthy litigation, conflicting judicial judgments, and we'd like to highlight some of these issues and what we think can be done through this discussion in terms of addressing some of them, and to use Dr. Subramaniam's remarks perhaps in an ideal manner versus in some cases practical as well. So with that, let me just jump to the questions. I think it was mentioned that there was a standing committee on finance in Parliament led by Jayan Sinha, which just completed a report actually on the IBC very recently, a few weeks ago. And some of the issues that were highlighted were, for example, that there are over 13,000 pending IBC cases with the NCLTs, which is equating to about 9 lakh crores. 71% of the cases are more than 180 days in the process. So let me just ask all of the panelists, what have been some of the major roadblocks under the code which are causing the inordinate delays in processing and disposing of these cases? And what measures can different stakeholders, the judiciary, resolution professionals, the COC, lawyers, take to improve the efficiency of the process? Let me start by asking Kaustubh if you could provide your views as an investor. You're on mute, Kaustubh.
Okay, am I audible now?
Yeah. Yes.
Yeah, okay. Thanks for that question, Nikhil. So I think before I get into the answer, just a very short comment, that coming from the steel industry, if you see what's happened over the last couple of years in the IBC regime, I'm personally a big fan of the IBC, process, because we've participated in several of these, and today, of course, there've been delays along the way, and we'll come to the reasons for that. But if you look at the net result really of what's happened over a period of time, you've effectively had the entire steel industry getting resolved, in a very constructive manner. even if you look at the outcome for all the stakeholders, these are not really assets which have eventually gone at distressed levels, really speaking. And, the acquisitions have been fully valued acquisitions, which is testimony of the fact that if the underlying assets are good, and if the law inherently provides protection to the new owner and the new management from the past actions of the erstwhile management and promoters, then you fundamentally have a very eminently workable solution. And with the commodity cycle and the way it's been behaving, I think it's been an excellent outcome across the board. There's been a lot of economic value which has been created, jobs which have been protected, so on and so forth. So with that opening, I'll come to your specific question, Nikhil, around the delays and the reasons for those delays, right? So I think there are delays essentially at two stages. One is the period prior to your actually bidding, in terms of as a resolution applicant, information availability is a major challenge in these processes versus any other normal acquisition that one looks at, right? Because you often find that the process is inherently hostile vis-a-vis the erstwhile promoter group, and therefore there is a sense of non-cooperation in terms of provision of information. Often there are governance issues, which is why books have not been appropriately maintained. There have been issues with regard to the resolution professionals, in terms of their ability to really, their experience, and therefore their ability to really handle these kind of processes to the optimal extent. And therefore, if you don't have the right amount of information available, you're really handicapped in taking the right decisions and putting the right value on the table. Or in other cases, if you do still fully value the asset, then you're hit with certain surprises that come to you later on. So I think this is the first challenge that you have. The second challenge, which was clearly, I think, brought out by the Honorable Chief Justice, was regarding the the delays in the judiciary, which unfortunately happen on account of the staffing issues at NCLT and NCLAT, and also because the NCLT and NCLAT don't just deal with IBC, they deal with a host of other issues relating to NCLT processes, etc., which result in significant amount of delays. So I think on that, I think numerous suggestions have been made in the past about not just increasing the bench strength, but also to explore whether it's possible to have dedicated IBC benches which are not distracted with any of the other work, and therefore which also kind of develop this whole mass of expertise over a period of time in IBC, which helps in resolving matters a lot faster. So I think these, to my mind, these are essentially the two key challenges till the time the asset really is resolved and comes into the hand of the new resolution applicant. Once it comes into the hand of the new resolution applicant, there are a series of other challenges that we've practically faced on the ground, but maybe more about that subsequently, since you spoke specifically of the initial challenges. So I'll just stop with that.
Thanks, Kaustubh. Suharsh, can I ask for your perspective on what some of the challenges that we're facing with the process currently?
Morning, Nikhil. Morning, everyone. Thanks again to CI for the opportunity. So I think I'll just start off by quickly also summarizing my view that IBC has been a great success. I think there is no taking away from that. But it's important that we're meeting at a forum like this so we can also discuss some of the deficiencies. We have Dr. Subramanian, there are policymakers over here who must be listening in. So I think it's important to also highlight some of the issues that practitioners are facing, so it can be taken up at the highest level. I'm aware of the paucity of time, so I'll come directly to your question, Nikhil, on what I feel are some of the issues that are plaguing the system at the moment and why there are delays. So in my view, the delays are primarily because of the functioning of two institutions. I feel COC to some extent, and with great respect, I feel the NCLT to a greater extent. So I'll start with the COC. So I feel the reason for delays at the COC has been a tendency amongst the COC members to not respect the sanctity of the timelines of a resolution process. So you've seen time after time that if a late bid comes in and the late bid is offering a 10% or 20% premium to the previous bid, even though it's coming after the deadline, the bankers tend to consider it. And this becomes an endless loop and we keep delaying the timelines. I think if we have a credible deadline, that credible deadline will not only be better for the bankers, but will also ensure that bidders put their best foot forward at the first instance and don't keep 10-20% in the back pocket to offer right at the end when the bids have become public. Secondly, I feel there is a very large anti-liquidation bias amongst bankers. Liquidation is not a bad word, and we should not consider it as a curse, because there are assets which are not ripe for resolution. And if an asset cannot be resolved, then from an economic perspective or a policy perspective, there should be no hindrance towards an effective liquidation. A COC can, practically speaking, in the very first COC itself, vote for liquidation of the company. But there is a tendency amongst bankers to push this down the line for 6 months or 9 months and wait for plans to come in. And once the plans are below a certain value, then they go in for liquidation. I think these two factors are leading to delays at the COC front. As far as NCLT is concerned, I think members on the panel have already spoken about the lack of judges. Now, there's a recent RTI application which was filed, Right to Information application, which shows that there are 31 NCLT judges whose appointment has not happened. So there are 31 vacancies at the moment. At a time like this, where we are emerging from a distress situation because of COVID, and the stress in the corporate sector is high, I think this is something which the government can, it's a controllable issue. It's not a non-controllable. If the government can look into this seriously, it'll really augment the capacity of the NCLT to resolve cases. Secondly, the Supreme Court and the NCLT have done a great job in laying down the law on various fronts. I'll stick to two. One is that the commercial wisdom of the COC must be respected, and the fact that the NCLT does not have any equity jurisdiction. It is a creature of the statute and it has to perform its role as per the boundaries set out under the statute. Unfortunately, at the NCLT level, these precedents have not been followed. And because these precedents have not been followed, there is subjectivity coming into decision making. And there are many cases where NCLT judges are using their subjective notions of what a good resolution is, because of which resolution plans are either sent back to the COC or are not being implemented in the manner that they should be. Lastly, there's also been a tendency amongst NCLTs to entertain frivolous petitions by promoters, operational creditors, and dissenting financial creditors. That tendency should be nipped in the bud. And technically speaking, the NCLT has the ability of dismissing these petitions on a summary level. NCLT does not need to issue notice, have detailed arguments on these points of law, because these are settled points of law, and it's merely leading to more delays. And sorry, before I sign off, the last point I'd also like to make is that there needs to be regular and continuous training of the judges of the NCLT, greater interaction with bankers, insolvency professionals, and corporate lawyers and industry heads, so that they understand the practical and commercial realities. Because very often we find that there is a mismatch of understanding between the counsel who are representing the case and the NCLT judges. One suggestion which I believe is also there in the parliamentary committee report is that the judges at the NCLT may be appointed only from the pool of high court judges or retired high court judges, because they are more attuned to high value commercial matters, and they'll also be able to better guide the technical members who are not necessarily lawyers. So I'll stop here. I'm conscious of the time, but very happy to, the second round to add on to this.
Thank you, Suharsh. That was very insightful, actually. Krishnava, can I ask for your perspective?
Yeah, hi. So yes, just I just echo everything what Suharsh says. Anyway, he's captured all of that. 2-3 things I'll add, but before that, I think what we're all ad item is that this is a great and incredible piece of legislation. It's worked. I've been fortunate enough to see it close quarters, being in the board of Bhushan Steel or Tata Steel, Tata Bhushan Steel now, where 3 years ago it was a bankrupt company. This spot it posted a 3,000 plus to EBITDA. So, the proof is in the pudding. I mean, that's where it is. In just 3 years, there was a turnaround. So the things are right. Yes, since the topic we're talking about is NCLT, all those issues of vacancies, of training, all that is there. But still, and these are not new suggestions. It's been suggested even earlier. We've had several rounds of suggestions, but things are not moving there. So whether it's time to probably look at something different, whether it's time that, we've been saying, the whole industry been saying about delays and vacancies there. Is there something else which is probably more controllable? More controllable. When I say that the delays are controllable, but to find the right judge for the right fit probably takes time. So one of the things which I've been actually suggesting is that if you look at NCLT and the process there, you will see a lot of these Section 7 applications. What a junior lawyer will take the judge through the portions of the pleading. My suggestion is that why can't we convert Section 7 applications, the Section 21 application, all those standard applications into only pleadings and no hearing? Let there be a Section 7 file, let there be a reply, let there be a rejoinder, because most of the substantial questions of law and fact have already been settled. So effectively, a Section 7 does not need argument, and keep the discretion with the judge. If at all there is a substantial question of law or fact, you can come back and call for a hearing if there is not passed the order. So the court does not get choked with a whole lot of these, like a Section 21, for changing an IRP. It takes 2 months, 3 hearings. Why? Or sometimes 3 months. A Section 7 goes, finally. So that's one part of it. The second part, I would not always blame the NCLT, and that's, please understand, at some level they are the quasi-judicial. So in a CY Industries, we saw what happened, and Suharsh is absolutely right by saying that the remit of the NCLT has been defined. Equity does not have any place where there is law specified. Commercial wisdom of the COC must be. But look at the judge who's sitting there. In a Section 12A, the judge said, listen, the statute says come to me. I am not an executive authority that I'll just stamp. If I'm an adjudicating authority, I'll have to adjudicate. Now, either you don't bring it in front of me, or if you bring it in front of me, then you won't call me an adjudicating authority. So, Section 21, for a change, why does it need to go before an adjudicating authority? If it goes before an adjudicating authority, it is right on part of the adjudicating authority to say that I need to adjudicate. I don't need to stamp. Or a 12-way resolution, which is a 90%, it says, so what happened, what we saw in CY, and there was a huge furor saying that how can, commercial wisdom, which is fine, but don't bring it in front of a judge. And therefore, if you bring it in front of them and say, now judge, now adjudicate. So the judge will get confused and say, do I need to adjudicate? Do I need to stamp? Okay, because I'm not a stamping authority. So I think these 2 points probably can be, one is there are several of these applications which you can do away with oral hearings, 7, probably a 10, probably a 21, and several more. You can do away progress report, all these which clog up the court time. And second, maybe tweak where you genuinely feel that the legislator wanted not to be adjudicated, but really a stamp, then don't bring it before them. It's unfair for them. And say that you come and you stamp, but you're not supposed to adjudicate. So these are the 2 points, and I'll probably, as I said, Suharsh has already put the whole list, so I don't need to add on that. Thanks.
Thank you, Krishnava. I just want to actually highlight two issues that were discussed. One was in terms of the steel assets that Kaustav spoke about that were priced fully in this process. I think the larger picture actually on this is that the question is, why are the other assets why is there such a significant haircut on the other assets? Is it because the quality of assets isn't as good as the steel assets? Is it that the loans that were made in the other sectors were not well appraised in terms of the underlying collateral or the prospects of that business in order to repay the loan? Or was it that something else went wrong in terms of during the course of the loan that didn't allow for the borrower to repay, whether intentionally or not? And I think that, you know, this is lost, and I find that a lot of it's a blame that the IBC is not working, when one has to look at what the underlying issue really is of how the loan was actually made, or in what context, what collateral was taken, and what happened during the period of the loan as well, to determine what the recovery is. And the second point I just wanted to quickly highlight is on anti-liquidation bias. I completely agree that I think that in the judiciary, I find that this is an issue. But I just want to highlight the other side of the story, which is from the creditor side, which is that if you look at the liquidation cases and what is the outcome of those liquidation cases, it's very, very poor. Financial creditors are recovering very, very little money in liquidation. And it's not because there's not value in the assets that are being liquidated. It's because the process is not actually fully developed that allows for an optimization of what the liquidation recovery is. So when a financial creditor has to assess whether it needs to be a resolution or liquidation, that creditor knows that if it's liquidation, he's going to get nothing, or if he gets something, it's going to take years and years and years, in which case he's really trying hard to find a resolution. And so I think that needs to be placed in context. Lastly want to just end with, in terms of my perspective on some of the challenges. I think we've talked a lot about what those challenges are. I wanted to provide some recommendations based on an extensive survey we did earlier this year with different participants, resolution professionals, financial creditors, judges, everybody really, law firms, everybody really involved in the process. And just quickly, one is, I think, capacity building at the NCLT. I think we've talked about increasing bench size, the number of judges, the pool of experts that can support the judges, providing a head for the NCLT, a president that actually is in office for a period of time, that can provide some quality and oversight to the institution. I mean, I really don't know why we don't have the full bench strength of 64. You know, it just doesn't make any sense to me. And I think this is the crying need of the hour. The second big thing is really in terms of improving the administration and infrastructure of how the cases are run. One is, of course, that we believe that if you look at other markets that are more developed in terms of bankruptcy, all of them have specialized agencies that actually conduct the administration of the cases. This issue is not left to the judges to manage. The judges are for adjudicating, so their time is optimized to adjudicate, versus being involved in personnel matters and dealing with other things that are non-judicial, that take up a lot of time in the process. And along with that is really driving the digitization of the NCLT, which I think has been a crying need that really was an opportunity in the pandemic for the NCLT to pick up, but unfortunately did not. And I think that everything from filings to hearings can actually be digitized, which will add a very significant efficiency improvement to the process. And it's something that we really need to take up, quite quickly right now, because we still have time to implement this. And it's always, better than not at all. And lastly, I think the other big issue really is in terms of the admission of these cases. We really believe, this is to Krishnama's point, that it shouldn't require 4 to 6 months for a case to get admitted when you have a default that has taken place, and which can be corroborated with somebody like an information utility that provides a certificate of default. It is not required that there has to be hearings related to this matter. It does not make any sense at all. And so these are just some of our perspectives on what needs to be done. I know we've crossed the 11:30 time barrier, so I don't want to.
We've just been given a little more leeway. We can go until 11:35 if you'd like.
Okay, all right. Thank you, Milind. Appreciate the extra time. I do have a couple of interesting questions that I want to ask the panelists. One is regarding to Kaustav. This is in terms of, there's been a lot of amendments that have taken place in the code, bringing in new stakeholders, getting home buyers as financial creditors. As someone who is an acquirer of stressed businesses, what amendments do you think would be helpful that would make it more attractive for you as an investor in this space? What would you like to see?
Yeah, thanks. So I don't know, as you rightly said, there's been, quite, I think almost 6 amendments to the, IBC, and a lot of the initial teething issues have been handled, but I'm not sure, therefore, if these are amendments, but I had 2 points that I specifically want to make, which we've seen as sort of pain points. One is during the CIRP process, given it takes so much time, we see there is a very significant destruction in the value of the corporate debtor during the CIRP process, because neither the COC nor the resolution professional, who's almost acting like a CEO, have the real capability to manage a business, right? And therefore, in some way, there needs to be a requirement that a professional agency, some sort of an O&M agency, should be running the operations of the debtor during this period to make sure that value is not destroyed in this period, because significant value can get destroyed in this period. The second point that I had was related to what happens after a new resolution applicant acquires the old asset. So in spite of all the regulations which are already in place, when you actually on the ground start operating the asset, you realize that with a lot of the agencies, especially government agencies, the revenue, tax department, so on and so forth, in spite of the NCLT orders clearly whitewashing all past liabilities, litigations on many of these accounts just go on till eternity, right? It's probably one of the reasons is that these departments are probably not educated enough about the entire NCLT process, and the fact that an order from the court really wipes out all past liabilities. But it's really a very, very strenuous process even after you've acquired it through an NCLT route. So to my mind, these 2 issues, one during the CIRP process and one of how one handles past liabilities after you take over, I think these need to be addressed in some form.
Also, I couldn't agree with you more on both of those issues. I think there's a significant amount of value erosion that takes place during the insolvency process if the asset is not managed properly, both in terms of cash flow as well as operational decisions that support the business through the process. I'm just going to ask one last question of Krishnava in terms of what are some of the challenges of getting financial investors? Costa obviously falls within the strategic investor category. What are some of the challenges in terms of getting financial investors like AIFs, distressed asset funds, private equity to participate in the process?
Yeah, thanks, Nikhil. I think that's an issue which needs to be addressed in the distress space. You have just one of the few Jindals and the Tatas who are taking the steel assets, but you have a lot more. Even they had in Monnet, they had a borrow banking there. You have a lot more entrepreneurs who may not have the balance sheet and need funds. Today we have the most peculiar thing, and for I just can't find the reason why it won't change. So you have 2 vehicles. One is the AIF and one is the ARC. And for a distressed capital, one of the main things is it has to have flexibility of the capital structure. So if there is a distressed fund needs to know that I decide whether I want to put into equity, I need to put it into debt. But the regulatory structure is such, for no reason, it's not changed other than the fact that there are 2 different regulators, is that you have one, which is ARC, where there is limited people who can invest and cannot take equity other than the conversion and only debt. So if someone wants to put an equity through ARC, they can't. And they need to search for an AIF. And on the other side, you have an AIF where you can only put in debt securities, okay, or equity and not loan. Okay. The only reason possibly, because we've been trying to find out, probably could be there are just 2 regulators. If today for a distressed fund, and there are lots of them, and distressed funds are obviously the source of capital for all these distressed assets. You don't have too many strategic, you have a handful there. So you need to reach out to these external distressed funds and ensure that you have a flexible pool where the distressed fund can come in and say, hey, I need to do mezz, I need to do debt, I need to do equity, I need to do pref. I should have the flexibility to do, which today they don't have. AIFs don't have surface rents. ARC has. So at some point of time, they need to change. And as I keep on saying that, I'll be happy to know what could be the reason other than the fact that, oh, if I give a loan in AIF, it'll come under the RBI domain. No. And there are ICDs. If I take equity in the ARC, because remember, this is a SARFAESI which is 2002, 20 years old. There were other considerations at that point of time when not conversion into equity. Today is completely changed, and that law must change because this is something we're facing very, very regularly in terms of flexibility of a capital structure for funds. They don't have avenues. They've got the cost goes up. You've got to have an AIF, you've got an ARC. Tax goes up because the AIF will invest in the ARC if you need to. So it just becomes unnecessarily complicated and for no good reason. And I think that needs to change because bad bank personally still does not resolve the issue. The bad bank, the bad ARC does not resolve the issue. You need a platform where you can attract capital, of course, with all the other issues which was a process and all that, and give them the flexibility.
Thank you, Krishnava. Milan, I think I'm going to wrap up the session right now. We're a few minutes over. Thank you for the time, everyone, especially the panelists.
Thank you very much, Nikhil. Thank you very much, Krishnava, Suharsh, Kaustubh. Those were very, very insightful comments, and I wish we had more time. I'm so sorry that we squeezed you guys, but it was very, very interesting, and I'm sure we could have heard you for another hour. But having said that, Chief Justice has left already. Chief Justice Kumar has left already. So thanks to him, and thank you very much, Dr. Subramanian. It was a great honor having you, and your comments were also very, very insightful and interesting. So from Subramanian, I'm going to hand over to Venkat Subramanian, who's the moderator of our next session, IBC 2016 and financial sector stakeholders experience so far and way forward. So Mr. Venkat Subramanian is a partner and head turnaround and restructuring services, ENY LLP. So over to you, Dinkar.